Hey guys, welcome again. Today we're going to be talking about, let's see. We actually landed up discussing whether you need to register your dietary supplement or your dietary ingredient. Let's now talk about how.
This is the Darshan Talks podcast, regulatory guy, irregular podcast with host Darshan Kulkarni. You can find the show on Twitter at Darshan Talks or the show's website at darshantalks.com.
So again, all the standard disclaimers apply. You'll have a list in the notes, if you will. But let's go back a step. If you have a new dietary ingredient, if you have a new dietary ingredient, as a company, you may still submit a notification to the FDA. So it may make sense to do that. So again, the company itself is responsible for evaluating the safety of the dietary ingredients it uses, and it must ensure that these dietary supplements are not adulterated. So who must actually submit this? Either the distributor or the manufacturer who uses a new dietary ingredient, either on its own or as part of a supplement. So if there's a new dietary ingredient in there, you need to let the FDA know. So what must be submitted? You need to submit the information on the basis of which you have concluded as the manufacturer or the distributor that the dietary supplement containing the new dietary ingredient will reasonably be expected to be safe. So when must this be provided? It must be provided at least 75 days before the dietary ingredient is introduced or delivered in interstate commerce, essentially before you start marketing it. So what must be submitted? Your name and address, the name of the new dietary ingredient, you need some details, the description of the dietary supplement that contains it, including the level of the new dietary ingredient, the conditions for use, the history of use, the company that is responsible for determining what information provides the basis, the signature of the person, and again, you'll need more details as you continue. So when you're talking about dietary ingredients, you'll end up talking about something called GRAS, which is generally regarded as safe. So the FDA created a list. There are GRAS notifications and self-affirmations, which are supposed to include the consideration of chemically similar or pharmacologically similar ingredients that are already approved and are being used in foods. You can provide the self-affirmations. These are generally not public unless they were later submitted to the FDA and are in the notifications bucket. And there are specific conditions that you can use in there. GRAS notifications is, again, a voluntary decision linked to a specific intended use outside the common use for probiotics. The law recognizes self-affirmed GRAS at the same level as a GRAS notification to the FDA. So essentially, whether or not you submit it to the FDA, you have to affirm that it works the way you wanted it to. Remember, you may need to actually notify the FDA after coming onto the market. Manufacturing requirements that you meet, so that if you are using a third-party manufacturer, how often are you going to be auditing that manufacturer? Any kind of serious adverse event. So again, you may need to reach out and have a person help you with a quality plan. Also developing what's called a HACCP plan, so a hazard plan, if you will. And if these are pieces that you think you need some help with, if you think you don't know how to work with these, feel free to reach out. I'm more than happy to help. Again, until then, subscribe. Until then, leave a comment. Maybe I can help. Maybe I can actually create another podcast or lecture that might be relevant. Stay tuned.
This is the Darshan Talks podcast, regulatory guy, irregular podcast with host Darshan Kulkarni. You can find the show on Twitter at Darshan Talks or the show's website at darshantalks.com.